Good afternoon, all.
Good afternoon.
Hello, Mr. Richards.
How are you?
Good. Mr. Richards, Mr. Richardson, and Mr. Watkins. We're just having some technical difficulties right now, so we'll be right with you.
Okay, thanks.
Good afternoon, all. Friday, the 29th day of October, 2021, appellant jurisdiction 2021, case number 30. Marley Watkins, the appellant, Fiona Miller, police sergeant respondent, Mr. Richardson for the appellant, and Mr. Richards for the respondent.
Good afternoon, everyone.
Good afternoon,
I was made to understand that the cause for the delay, sorry, can you please come back, Wendy, just for a moment? Thank you. Don't leave just yet. Sorry. I was caused to believe that the reason for the delay is because of our technical issues with live streaming. But the reason, sorry, when they asked for you to stay is because on my screen, it seems to indicate that we are in fact live streaming. Is that?
Yes, I'm seeing
Are you
that as
able,
well.
are you able to give some, shed some light? Because I don't detect a problem.
Yeah, the live stream does seem to be functioning.
So for the court associate, can I get a court associate either to respond to me on the screen or someone to come to my chambers, please, just so that I can. Gina, do you see the live stream indicator on the screen? Yeah, it looks like it's on for me. It appears so. I don't, that's exactly what I usually see when it's live streaming. So, sorry, I don't have a mask on. Okay. Gina, can you confirm that the court smart is on? Because that's particularly important. Okay. Okay, so I've had a double confirmation that court smart is running. I don't think that we should wait any longer. I want to start. It's no, it was half an hour delay in start time, yes? Okay. All right, so Mr. Richards? Any
Yes,
reason
my lady.
why, or even Mr. Richardson, any reason why we shouldn't start? Everything looks up and running to me.
Yes, I agree, my lady. I think we should start.
Yes.
And I don't think we're going to take particularly long, respectfully. I did notice that when the case was called, I think my learning friend and I were the wrong way round. So I actually appear for the appellant.
You're the appellant, yes.
Yeah. So your ladyship should have some written submissions that were filed by me. They are dated the 12th of October.
Yes.
They were filed in support of the appeal by the informant, but also in response to the cross appeal. The cross appeal has been formally abandoned. Mr. Richardson also has provided some written submissions.
Can we just confirm that that's Mr. Watkins who appears?
Oh, I'm sorry. Yes, of course.
Okay, Mr. Watkins, that's you? Your name's Marley Watkins?
Yes, it is, Mother, or Judge.
Can
Yes,
you just say- Yes, thank you.
yes, it is.
All right. Yes, continue, Mr. Richards, yes.
Thank you, my lady. So you'll also remember from our brief appearance before you, when this matter was first listed, albeit in Mr. Watkins' absence, that there was some discussion about the position of his former co-defendant, Miss Infante. Miss
I remember
Infante.
all of that, yes. All
Yeah.
that background is still fresh in my memory.
Excellent. So she is no longer practically the court's concern because she was deported on the 2nd of October.
Mhm.
And there is no realistic prospect of the Crown successfully extraditing her back to serve the balance of her sentence, even in the event that your ladyship is persuaded that it too should be increased. And I do recognize, and I think my learned friend may make something of this, that means that there is potential for Mr. Watkins to feel at somewhat a disadvantage. I mean, if your ladyship does conclude that both sentences ought to have been longer, which is the proposition for which the Crown contends, then the practical reality is that only Mr. Watkins will be available to affect any change. And I can see that may leave Mr. Watkins feeling some injustice, because obviously the fact that the Crown wasn't able to prevent Miss Infante from being deported at the time that she had completed a sentence, or get the matter before this court in time for it to do anything before that occurred, is of no fault of his. Mm-hmm. My concern primarily in bringing this appeal is not really focused on Mr. Watkins personally, but on ensuring that precedent is respected. And it is my contention fundamentally, and I really have 2 points of substance on this appeal, that the precedents set by the learned former Chief Justice, principally in the case of Lauren Davis, but also reinforced in a judgment that he also issued, that was not, I accept, and I noticed that Mr. Ritson makes this point in his submissions, before the learned senior magistrate when he dealt with this matter, but that's the 2 appeals of Elisa Holder and Henry Huggins. That, in my respectful submission, reinforced what former Chief Justice Caverley said in the Lauren Davis matter. And my fundamental contention is that the learned senior magistrate has misapplied those authorities, coming to the conclusion that a shorter starting point was justified by them than in fact it was. And I intend to take you to the sections of those judgments that I respectfully submit indicate what the general conclusions and guidance that the former Chief Justice gave amounted to. There were reasons that I'll get into in more detail why he didn't necessarily follow through to imposing quite as high a sentence on the Crown's appeals as he might otherwise have done, different reasons in each case. But I would respectfully submit that we need to focus more on what he said by way of general application and guidance than the particular results in those cases. And had that been applied in this case, I submit that the learned senior magistrate would have alighted at, or upon rather, a longer starting point than in fact he did, and he would not have discounted it as significantly for various factors as he did. And respectfully, I take the position that the other decisions of this court that were before the learned senior magistrate, and to which he appears to have attached some significance, I think both from recollection decisions of your ladyship, but in rather different factual scenarios, in my respectful submission, namely Tafaro Wilson and Natasha York, are, I would say, particular to their rather peculiar facts, and don't really assist in the resolution of the appropriate sentence in this case, or in a case that presents these features. And obviously every case is different. This case has some unusual features, and in particular it has a relatively unusual procedural history. One of the most significant, remarkable details about it is that on the factual findings of the magistrate's court, with which I do not quibble, I think Mr. Ritson may tentatively suggest in his written submissions that he doesn't entirely accept the determinations that the magistrate made, but I am, for my part at any rate, content to accept the factual findings that the learned senior magistrate made, which were, of course, to reject the contention that this was a small-scale importation, but equally also to reject the contention that there was as much as £2 concealed in each of these hardback books. And I appreciate that in saying that, I may be starting to get into some of the facts with which I don't know that your ladyship is particularly familiar yet. The agreed...
I consider myself to be broadly familiar with the facts. I read the amended summary of evidence that was on the record.
Thank you.
Which I found to be helpful.
Yes, and your ladyship will appreciate then that there are a substantial body of agreed facts, and I think that the summary does a reasonable job of setting those out. There were then some areas of disputed fact, and the undisputed facts are set out in the written ruling of the learned senior magistrate
Yes.
appears in the record.
Mhm.
In particular, he starts at paragraph 5 of the written ruling, which your ladyship can find on page 11 of the record. And I think that continues to paragraph 15. So there's probably not a need for me to go through those slavishly, because your ladyship's already read the summary, and if you haven't yet already had the chance to read the learned senior magistrate's ruling in full, I know that you will. But it's really only from paragraph 16 onwards that we get into the disputed facts. The point that I just wanted to flag for your ladyship's attention now, and really it's the sort of second substantial submission that I'm making, is that an important feature of this case, an unusual feature, obviously, because the vast majority of drug importation cases involve an interception on the way in, and this case involved an interception on the way out, by which time the drugs had already been delivered, or in fact collected, by Mr. Watkins. And an important point in this case, in my respectful submission, is that the learned senior magistrate found that the totality of those drugs was in the region of £half a pound in each book, and so a total of £2, and much greater than the 3 ounces that the other defendant was to say in evidence had been the subject of the conspiracy. And albeit that this appellant did not give evidence, he didn't, through cross-examination of his former co-defendant, challenge in any way her evidence on that point. But so insofar as we can divine what he asserted the quantity to be involved was, it would appear it was the 3 ounces that she spoke to in the course of her testimony. But that was rejected by the learned senior magistrate, and he concluded that the importation was in the region of £2 or 100,000.
That was the subject of the Newton hearing?
I beg your pardon, my lady?
I see that there was a Newton hearing.
Yes.
Is that was the subject of that?
That's right, my lady, yeah. So that was the primary issue on the Newton hearing. And so Mr. Watkins had to be sentenced, and I mean, certainly insofar as he explains his reasoning, was sentenced on the basis that the subject of the conspiracy was $100,000 worth of this high THC content plant material. And your ladyship will know that only a very small quantity of cannabis was in fact seized during this investigation. It was less than 10 grams, if I recall correctly. And so that means that the vast majority of $100,000 worth of cannabis is in the wind, it would seem. And in my respectful submission, the learned senior magistrate fell into serious error when he concluded that in those circumstances, Mr. Watkins deserved either any substantial credit for his guilty plea or the mercy of a partially suspended sentence in circumstances where he had not even said to the court, here is the balance of the cannabis that I accept was imported. He didn't even offer up the difference between what was recovered and the 3 ounces, which we assume he was saying had in fact been imported, and certainly not the balance of what was between what was recovered and the £2 that the learned senior magistrate found was a subject of the conspiracy. And that factor, in my respectful submission, is absent, obviously, from the vast majority of drug importation cases, because the entire quantity is intercepted on arrival into the jurisdiction. But this
conspiracy, sorry, you're saying a drug importation case, you mean just on the facts?
Yes, my lady, yes. I'm sorry, I'm not sure that I understand why.
I thought that the information before the court the charge concerned was conspiracy.
Yes, but I don't know that it makes a huge difference, Melody. I mean, obviously, sentencing in drugs cases, I can't remember the name of the number of the section now, but there isn't, generally speaking, a significant difference in the approach of the courts to sentencing for conspiracy to import and importation. The general rule that conspiracies, the maximum sentence for conspiracy is half the maximum for the substantive offense doesn't apply in drugs cases. So I don't discern a significant difference in
No, sorry, not in terms of sentencing, but you're saying in the majority of importation cases, you usually have an interception.
Yes.
And it seems to me that the observation to make is in the majority of conspiracy cases, you don't.
I don't think I do accept that, milady. No, I think that sometimes a conspiracy to import is charged in substitution for importation precisely because there was an interception, but the interception occurred before the drugs arrived in the jurisdiction. That happens sometimes.
Right.
Sometimes so I mean, your ladyship, I think must therefore have in mind a conspiracy where the drugs are not recovered.
Well, no, you're talking about the peculiarity of this case in the sense that on the facts, in the sense that the drugs were not intercepted on arrival to Bermuda. But factually, I just look at it from the standpoint that, well, the Crown has proceeded on the basis that this is a conspiracy case and
yes,
drugs were not intercepted, and that's not, it would not seem to me that would be particularly unusual if you're highlighting the fact that the drugs were not intercepted.
Yes. Well, I'm trying to think of as many examples as I can, but I don't actually think that it necessarily follows. I mean, certainly I am thinking of conspiracies to import that I have dealt with where the drugs were intercepted. It's just not necessarily at the airport. I mean, if somebody arrives with drugs in their physical possession at the airport and they are found by
Likely to be charged with importation.
Exactly. But if there is a consignment of drugs that's intercepted either overseas and then there's a controlled delivery,
right,
and so the drugs aren't actually under the control of the defendant at the time that they're imported, then it may well be that conspiracy is charged instead. I'm struggling to think of an instance of where, as here, the drugs have been on the evidence successfully imported and never located. Mr. Richardson may know of such a case. I can't think of one in my time in Bermuda.
Well, I mean, I'll hear from Mr. Richardson in due course, but I take from all of that your submission is obviously that makes this case peculiar.
Yes, and in a way which doesn't advantage the defendant. I mean, that every case obviously turns on its own facts, but I can certainly see and accept that if Mr. Watkins had come to the court from the get-go and said, here is the cannabis that was the subject of the importation, whether he was saying it was 3 ounces or some other quantity, that the court might have attached some weight to that in approaching the question of sentence in his case. But having determined that he was a co-conspirator in the importation of some 2 pounds of cannabis, the vast majority of which on the evidence was collected by him from the hotel at which Miss Infante was staying and then never seen again. In my respectful submission, to approach the question of sentence in his case in the way in which the learned senior magistrate did was to afford Mr. Watkins too much credit in the circumstances, because the only person, as far as we are aware, who can know where all of this cannabis has gone is Mr. Watkins, and he has never said anything about it. And there was no, just to emphasize this point, there was no evidence, positive evidence as to that in the Newton hearing at all, because Mr. Watkins didn't give evidence. And I know that Mr. Richardson blames that on his former counsel to at least some extent. But Mr. Watkins didn't give evidence. Miss Infante wasn't going to be able to speak to the issue because she was in the hotel when the drugs were collected from her. Mr. Watkins came and collected them, and there's no reason to suppose that she would have known what he did with them other than if he told her, which obviously would have been hearsay. There were some suggestions that were put to one of the police witnesses, not by Mr. Watkins' counsel, but by Miss Infante's counsel, that there were some more distant areas surrounding Mr. Watkins' house that had not been searched in the course of the search of his home, during which the small quantity of some 10 or 20 grams was recovered. I think it was less than 10 grams, actually. But there was no positive evidence as to what had happened to even the 3 ounces that Miss Infante was to testify had been the subject of the conspiracy. No explanation of that provided to the court at all. And in those circumstances, in my respectful submission, this is a more serious case than the sentences that were imposed tend to reflect. So getting, if I may, into the substance of my submissions, I do respectfully adopt the outline of the undisputed facts in this case that is set out at paragraphs 5 to 15 of the learned senior magistrate's detailed ruling on sentence, which appears in the record of appeal. So far as the mechanics of the Newton hearing are concerned, in case your ladyship should be wondering, there was not in fact a written basis of plea put forward by either of these defendants. And Mr. Richardson, just for the sake of the record, didn't represent either of them at the start.
Counsel in the lower courts, I saw that.
Okay. So it was Mr. Scott and Mr. Swan to start out with. Mr. Scott was replaced partway through by Mr. Daniels as Ms. Infante's.
Daniels was invented. Sorry, I'm just speaking in relation to Mr. Watkins.
So just in relation to Mr. Watkins, it was Mr. Swan in the court below, and now it is Mr. Richardson.
Okay, thank you.
So there was no written basis of plea, but initially it was contended on behalf of both defendants that the conspiracy was limited in scope to the cannabis that was seized from Mr. Watkins' home. And your ladyship can see what that was listed in paragraph 15 of the learned senior magistrate's ruling. This is page 14 of the record.
Yeah.
I was speaking somewhat imprecisely earlier, and apologies for that. So it's actually listed out in those 3 Roman numeral paragraphs. So there was some 6.72 grams of cannabis in 4 canisters, and there was some plant material in the laundry room which was less than half a gram, and 0.11 grams of cannabis resin. So significantly less than 10 grams was what was actually recovered from Mr. Watkins' residence. Now, moving on from the undisputed facts, the learned senior magistrate then made findings in relation to the disputed issues as between the parties, which we've touched upon the principal elements of. They are set out paragraphs 16 to 18 of the learned senior magistrate's judgment, and they quote substantially from an earlier document that he had issued, detailing his factual findings specifically. So that was issued at the conclusion of the Newton hearing. And I don't think that your ladyship has actually been provided with that document separately.
What document?
The document that the senior magistrate is quoting from in paragraphs 16 to 18. You'll see that both all 3 of those paragraphs contain substantial quotes in italics, and they are quotes from his own ruling on the Newton hearing.
I do
where
have that. It's on the record.
Oh, you do have it. I'm
Yeah,
sorry, I
it's on-
couldn't see it.
It's on page 41 of the record.
Oh, yes, I'm sorry. You're quite right, my lady. Yes. I was misreading the contents. Yes, so that is the document we're talking about. Correct. So, my lady, he found that the conspiracy extended well beyond the 3 ounces of cannabis that Miss Infante said she'd imported. He found that the agreement had been to import some 2 pounds, so a little less than a kilo, 907.19 grams of cannabis, with a street value of just in excess of $100,000. He further found that the purpose was jointly medicinal, which is what was contended by the defense, albeit again via only the evidence of Miss Infante, Mr. Watkins not having given any, and recreational, which was not the defense case, and that at least some of the drugs were intended for supply to others, but that the purpose of such supply was not commercial. He assessed Mr. Watkins as having a more significant role in the conspiracy, being one of the organizers than Miss Infante, whom he assessed as playing a more secondary role.
Mm-hmm.
Now, as will hopefully have been apparent to your ladyship, it was the prosecution's primary contention during the Newton hearing that the quantity of cannabis involved significantly exceeded not only the small amount that was seized, but also that which Miss Infante asserted in her evidence. Prosecution also contended that the drugs were intended for supply and that the arrangement was a commercial one. In result, however, applying the burden of standards of proof, the court agreed with the Crown only as to the first 2 of those propositions, but not the third. So it did not find a commercial motivation to what it did find to be an intention to supply at least some of these drugs. It did, however, and this in my respectful submission is material, find that the drugs were more than 10 times the amount accepted by the defense. As I think I've made clear, I regard for this purposes the Crown is bound to respect the factual findings of the learned senior magistrate, even to the limited extent that we contended for a finding of commercial supply. And I've set out in paragraph 6 why it is that I say that has to be the way in which I advance this appeal based on section 4A of the Criminal Appeal Act. Now, I then go on to consider in paragraph 7 of my written submissions some comments contained within Mr. Watkins' notice of appeal. And I think to the extent that they have found their way into his response to this appeal, they are put in quite a limited way. So I probably don't need to go through those in quite as much detail as I had apprehended before that appeal was abandoned. It suffices to say in my respectful submission that to the extent that the findings were adverse to Mr. Watkins, they resulted from a proper application of the burden and standard of proof to the evidence presented. That did not, of course, include any positive evidence from Mr. Watkins, who chose not to testify in his own behalf, even to explain the whereabouts of the drugs that were not recovered by the police, which on Miss Infante's evidence must have existed even if they were not as extensive as the prosecution contended and the court ultimately found. So in the result, Mr. Watkins received a sentence of 9 months imprisonment, with 3 months of that suspended for 2 years. I respectfully contend before your ladyship that that sentence was manifestly inadequate and should be increased. It is submitted that it was both too short and that no portion of it ought properly to have been suspended in the circumstances. The same submissions are made respectfully in respect to the sentence imposed on Miss Infante. I do not, however, challenge the decision of the learned senior magistrate to differentiate between the two, because in fact, as your ladyship will see from the notes of the sentencing hearing, such a differentiation was contended for by the Crown, albeit we proposed higher starting points. So if I can, I'll turn your ladyship's attention now to the case of Miller and Davis, which can be found at page 325 of the record. This is the first of the two judgments of former Chief Justice that I alluded to earlier.
Yes.
So, my lady, this case concerned, as you can see from the first page, the importation of 608.81 grams of cannabis. That's set out in the summary of facts beginning at paragraph 2. The street value of those drugs was $60,850. And your ladyship will see that paragraph 3, the respondent was sentenced to 6 months imprisonment by the magistrate's court. The court found that 12 months imprisonment was the basic sentence, and the respondent was entitled to a discount of 50% for her cooperation with the police, and appeals against that sentence on the grounds it's manifestly inadequate. So again, this was a prosecution appeal. Now, turning forward to the conclusion of the judgment, you'll see at paragraph 44, my lady, and I do note that this paragraph has been marked. That mark, I assume, is the senior magistrates.
Yes.
Accordingly, the sentence of 6 months imprisonment is quashed and substituted with a term of 8 months imprisonment. This assumes a basic sentence of 12 months with a discount of very nearly 35%. Now, that discount was for assistance offered to the police, not a feature of the case that is before your ladyship today, but one which justified a discount in this case. And of course, I respectfully characterize the circumstances surrounding the unrecovered drugs as almost the opposite of assistance, but there it is. In my respectful submission, we have to look, and I think I've already said this, so I'll be brief. We have to look at the general propositions that the Chief Justice alighted on in the course of this judgment, perhaps rather more than the result that he arrived at in the particular case. And I hope it will become clear why I say that is so. Could I ask your ladyship, please, to look at paragraph 15 of the judgment, which is on page 326.
Yes.
Because it will be apparent from what I've said thus far that such increase as there was to the sentence in that case was relatively modest. But there is more to glean from the judgment than that, in my respectful submission. Paragraph 15, the learned former Chief Justice says, in summary, Davis and Fox affixes a tariff for cannabis importation sentencing which is inconsistent with modern sentencing trends. The Crown conceded just over a year ago that 5 years imprisonment is the basic sentence for a cruise ship employee importing an amount of cocaine comparable in street value to the cannabis resin involved in the present case. Basic magistrates court sentence for importing a comparable amount of cannabis resin without aggravating factors today must be in the range of 1 to 3. Must be in the 1 to 3 year range, with the present case being 608.81 grams of cannabis at the value of 60,850, probably falling in the middle of the range. And I commend really the rest of that discussion, but I don't want to take your ladyship through each and every line of it. I'd ask you perhaps now to move forward to paragraph 19.
Yes.
Where his lordship says the appellant has demonstrated, the appellant obviously being the Crown, for the first time before this court, the Supreme Court, that the basic sentence for similar offences of importation in the future ought to be in the range of 1 to 3 years immediate imprisonment, having regard to the quantity and value of the drugs involved in this case and taking into as a mitigating factor, I think there must be a word missing there. I think it must be taking into account as a mitigating factor the assistance given by the respondent. An appropriate term of imprisonment would, in my judgment, have been 2 years, or looked at from another perspective, had the sentence of 2 years imprisonment been imposed on the respondent, she could not have complained that such a sentence was harsh and excessive. So it is important, in my respectful submission, to appreciate that his lordship was not saying that the sentence he ultimately imposed of only 8 months imprisonment was the right sentence in the Lauren Davis case. He was saying that it should have been in the region of 2 years, but there were reasons why he didn't regard it as appropriate in the particular circumstances to substitute that sentence. And he explains that a little bit. However, this position was not advanced or substantiated in the initial sentencing hearing. The learned senior magistrate's chosen tariff fell within the range of possible sentences he could probably impose, both A, based on the very limited precedents he was invited to consider, and B, based on the further precedents placed before this court. There was no error in principle, nor was the basic sentence of 12 months shown to be obviously lenient in regard to other comparable cases. The limb of the appeal accordingly fails. So really, I interpret the learned Chief Justice as saying, and he says a similar thing in the next case that I want to come to, Henry Huggins, that the Crown didn't really set out its stall sufficiently before the learned senior magistrate to then complain about the sentence that had been imposed on appeal. He's saying that it ought to have been 2 years, but he's not persuaded to increase it that much, and only substituted the sentence that we have alluded to. I've also marked paragraph 41, which is in the section of the judgment that deals with the disposition of the appeal. Court below did not err in principle in selecting 12 months imprisonment as the appropriate level of basic sentence. However, this sentence was at the very bottom of the applicable sentencing range, and indeed below the sentence I would have considered to be appropriate if I were exercising the sentence discretion afresh. Based on the material placed before the sentencing court, it cannot be said that the sentence was imposed was manifestly inadequate. So that just restates the point in my respectful submission. It should have been significantly longer, but the Crown didn't say enough before the magistrate to justify the length of sentence that the Chief Justice was persuaded would, in fact, if he were doing it all over again, have been appropriate. And so although the Crown won its appeal, it didn't get the full increase for which it was contending. And then there is the judgment in the case as conjoined appeals, I suppose, of Valisa Holder and Amanda Henry Huggins. Now that judgment was appended to my written submissions. Does your ladyship have that?
Yes, I do have it. Just give me a moment. Yes.
So, my lady, if you would turn, the first page is taken up entirely by the title of the proceedings, but turning to the second page, there the learned former Chief Justice highlights the facts of the two matters that were before him. In respect of the appellant Holder, which is the one that I respectfully submit is most relevant for these purposes, that was a person of previous good character, common to this respondent, having been convicted following a trial of importing and possessing with intent to supply 1,101.85 grams of cannabis, so a bit more than was involved in this case, worth between 19,000 and 55,000, but worth rather less because of a quantity, I can only assume, was sentenced in the magistrate's court by the Worship of Tyrone Chin on the 18th of April 2017 to 2.5 years imprisonment. She appealed on the grounds that her sentence was harsh and excessive. So turning through the judgment then, the learned Chief Justice reiterates what he said in Lauren Davis. He actually quotes from that judgment at paragraph 6 of this judgment. And then if I could direct your ladyship's attention to paragraph 12 of the judgment, which is on page 7. Following this court's decision in Miller Davis, and in the exercise of the broad discretion conferred by Section 18.3 of the Criminal Appeal Act 1952, I quash the sentence of 2.5 years or 30 months imprisonment, gravity of the offence by reference to the type and quantity and or value of the drug imported is broadly similar to that in Davis, where 2 years was found to be what this court would have determined to be the basic pre-discount sentence. However, in determining what alternative sentence it is just to impose in place of the original sentence, I am bound to take into account the disparity between the appellant's sentence and those imposed upon her fellow prisoners, Henry, Huggins, and Smith. And Smith was another case dealt with in the magistrate's court that I don't think was appealed by either side, but which is cited briefly in the course of his lordship's reasons. I take judicial notice of the fact that female prisoners represent a comparatively small group detained in the same correctional facility. It is self-evident that the appellant's sense of injustice will be greater as a result, because her contact with the beneficiaries of more lenient sentence is likely greater than would be the case with the ordinary male prisoner at Westgate. I accordingly substitute a sentence of 22 months imprisonment, or 1 year and 10 months, for the sentence of 30 months imprisonment originally imposed in the magistrate's court. So 30 months reduced to 22 months for the reasons that are identified in paragraph 12 of the judgment. So there, in my respectful submission, the learned former Chief Justice is re-emphasizing that he was not saying that the outcome in Davis necessarily should be repeated. And I would respectfully submit that we have to pay rather more regard to his remarks at paragraph 19 of that judgment, and also paragraph 15 in determining what the sentencing range and relevant starting point should have been in a case such as this. And obviously, the magistrate who initially sentenced Miss Davis did not have the benefit of the analysis of the other case law that the Chief Justice performed in Davis. And that obviously was before, because the Crown relied upon the judgment in Davis, the learned senior magistrate, when he came to sentence Mr. Watkins and his former co-defendant. It's apparent from his written reasons, respectfully, my lady, that the learned senior magistrate placed considerable reliance upon the judgment of this court as it is constituted today in the appeal of York against Miller, which is reproduced at page 310 to 319 of the record of appeal. That's a case which I imagine your ladyship will recall well. With respect, it presented.
I might need you to refresh my memory.
Of course, my lady. So 310 of the record. Now, I have a note here that your ladyship, in the course of your judgment, described the circumstances of that case as unique. I must confess that I am not immediately able to locate that term within your ladyship's judgment, but I believe that that was a word that your ladyship used in the course of the judgment to describe those factual circumstances. So at the time that she appeared before your ladyship, the appellant was 44 years of age. The facts.
I see it's on the bottom of page 8 of the judgment, paragraph 20.
Oh, thank you, Melanie.
Where I say, but for such unique circumstances, I would agree that an offense, etc.
Yes, indeed. I'm very grateful. I was actually going to take it later to paragraph 7, but it may well be that
Which authority are we in now?
This
We're
is
looking
your-
at the Natasha York judgment on page 310 of the record, but specifically page 317 of the record,
Thank you.
paragraph 20.
So your ladyship sets out some circumstances there. 41 years of age, mother of 2 daughters of minor age with no criminal history or suggested criminal affiliation, and an early guilty plea. It was clearly accepted by the Crown and by the magistrate that the appellant had no intention of sharing the imported cannabis with any person with any other person, and that her sole purpose for bringing the substance to Bermuda was to privately smoke it as a means of relieving herself of regular and injurious seizures. Given the facts of this case, I find that it was
I remember this, yes.
I suspected your ladyship would, once you'd had your memory jogged. I mean, it is an unusual case factually, in my respectful submission. So given the facts of this case, I find it was particularly harsh and unreasonable for the magistrate to compel the appellant to serve a 3-month portion of a 12-month custodial sentence. While this was a case of importation involving 1,430.7 grams of cannabis, a little bit more by weight than involved in this case, factual reality is this case bears more resemblance to an offence of simple possession by a first-time offender, driven by desperation to avoid medical treatment and healing from a serious and chronic ailment. But for such unique circumstances, I would agree that an offence of importation of 1,430.7 grams of any illicit substance would otherwise result in an immediate term of imprisonment. So in my respectful submission, it is a factually rather dissimilar case, because although Mr. Watkins contended that some of the cannabis that he imported was for medicinal purposes, the learned senior magistrate found that what was imported in this case, in fact, was to be used for both medicinal and recreational purposes. And further, the learned senior magistrate found that some of it, at least, was intended for supply and not merely for personal consumption, as your ladyship found was the case. And in fact, as I think the Crown accepted was the case in the York matter. So I do have to accept that the learned magistrate did recognize some of the crucial differences between that case and this, and he in fact summarized the paragraph 28, Roman numeral 5 of his written ruling. Having done so, however, it submitted that he proceeded to place too much weight upon the exceptional course that this court deemed appropriate in that case because of its peculiar facts, by which I mean the suspension of the whole of a 12-month period of imprisonment. On the magistrate's factual findings, this case simply cannot be said to, and here I'm quoting from your ladyship's paragraph 20, bear more of a resemblance to an offence of simple possession. In that regard, the court will bear in mind that upon the learned senior magistrate's factual findings, the vast majority of the 2 pounds of cannabis that he concluded had been imported in this case has been put beyond the reach of the authorities. And so, respectfully, my lady, the prosecution contends on this appeal that the learned senior magistrate erred when he concluded that it was appropriate to afford Mr. Watkins and Miss Infante normal discount for their guilty pleas, albeit that their pleas were entered in the early stages of the proceedings before any trial date had been set down. The fact that the court decided the principal factual issues that were presented to it on the Newton hearing against them can only reasonably and logically mean that they should not be entitled to the full third credit that would attach to an early and unequivocal guilty plea. The Crown's case, based on the evidence from Sergeant Saints, and your ladyship actually has his witness statements in the record and may refer to them if you need to do so, was that between half and 2 pounds of cannabis had been concealed within each of the 4 books that were brought into the country by Miss Infante. Crown did not positively assert that anyone could be satisfied so that they were sure that the quantity was as high as 2 times 4, namely 8 pounds. Indeed, before the Newton hearing commenced, and obviously long before Mr. Richardson's involvement in this case, I have to concede, the Crown indicated that it would be willing to accept pleas on the basis that the total amount that was imported was just £2, half a pound in each book. That was the bottom of Sergeant Saints's calculations, and we said that we would accept that, but that offer was not accepted by the defence. If it had been, then of course this would have been an entirely appropriate case in which to afford both defendants the full third credit for their guilty pleas. But it wasn't. There was a Newton hearing, and I respectfully submit the principal factual issues were decided against them, albeit I do have to accept that the Crown was not successful in establishing commercial intention. In my respectful submission, the learned senior magistrate fell into error when he selected as his starting point in this case a sentence of only 12 months imprisonment. I submit that based on the authorities, and in particular the range identified in Davis, the starting point ought to have been higher, and indeed in the region of the 2 years for which the Crown contended at the sentencing hearing. Limited discount for a guilty plea and personal mitigation, which I do not doubt Mr. Watkins probably has, ought not to have reduced the ultimate sentence imposed in his case below one of 18 months. It must be remembered, in my respectful submission, that a defendant's personal circumstances, such as the existence of a dependent partner or child or anticipation of such in the future, will generally be far better known to him or her than to anyone else before he or she chooses to embark upon a course of criminal conduct, particularly one that requires a degree of planning or organization and cannot therefore be said to be purely opportunistic. The value of such considerations can subsequently have as mitigation, must therefore be scrutinized most carefully. And here I pause to take your ladyship very briefly to an entirely unrelated case factually, Batchev and Todorov, which was a fraud case, but perpetrated by a couple of visitors to the islands. And paragraph 11 of that judgment, which is appended to my written submissions, the Court of Appeal said something of more general application, which I respectfully reiterate here. The fact that someone chooses to commit crimes whilst visiting Bermuda and is thereby unable to maintain family life while serving a prison sentence because their family is abroad is not mitigation. I think that it had been contended in that case that the appellants, or rather the respondents in that case, were entitled to some discount because they their families were back in the country from which they had come, and they had indeed been afforded some discount to reflect that when sentenced by this court. The Court of Appeal found that was not a significant mitigating factor, because obviously those were all things that the defendants themselves could have taken into account before committing the relevant offences. In my respectful submission, the magistrate erred when he concluded in this case that any portion of the sentences imposed upon this respondent and Miss Infante should be suspended. Your ladyship will know from a sequence of cases that I believe have come before you, Tafari Wilson. Also, I recall, I think the ladyship addressed the point in Mandaya Thomas, and considering the judgment of the Court of Appeal in Garth Bell, that there is no longer a gloss to be put on the test for suspension to the effect of exceptional circumstances. So I'm not suggesting that the learned senior magistrate had to find that there were exceptional circumstances before he could suspend. But my contention is that even the good reason standard that is now clear from the case law was not satisfied in this case. In my respectful submission, there just was no good reason. And I respectfully submit that the learned senior magistrate doesn't really seem to say clearly in the course of his sentencing reasons what good reason he found to suspend any portion of the sentences that he saw fit to impose. And in particular, in that regard, I recall that your ladyship found that the learned magistrate's decision to suspend the sentence that was imposed upon Tafari Wilson was justified by a finding that it was a one-off offence.
Where is the Tafari Wilson?
297 is where it starts in the record of appeal, my lady. And I mean, obviously, your ladyship knows better than anyone else what it was that you were saying in that judgment. But the way I read it is that you weren't necessarily saying that you agreed with the course that the lower court had taken, but it was within that court's proper discretion and you weren't going to interfere with it. And I believe that in the course of holding that, you found that the one-off nature of the offence was capable of justifying the decision in favor of suspension.
Tell me something, is Garth Bell cited in this decision?
In Tafari Wilson,
Yeah, it doesn't.
I don't think it is, my lady. I think
Only because I'm trying to remember. I know that there was a matter that came before me, and I think it would have postdated Tafari Wilson, where Garth Bell was brought to my attention.
yes.
And
I have to say, my lady, I'm a little bit puzzled about that because I did the first set of written submissions in Tafari Wilson, and Garth Bell was mentioned in those submissions. So I don't know why it was that your ladyship didn't address that case in the Tafari Wilson judgment. I assume it was, I think you were presented with a further set of submissions subsequently, and it may be that you didn't have my submissions before you when you were writing the judgment. But I do recall that when you issued the judgment in Medea Thomas, you said that it was unfortunate you had not been referred to.
yes, so it was Medea Thomas where I
Yeah.
dealt with suspension.
And I was surprised by that because I said to myself, I know I did put it in my submissions, and I
Right.
checked and I had, but for whatever reason, obviously didn't come to your ladyship's
Maybe I
attention.
can make a passing comment about that if it's relevant for me to deal with suspended sentences here.
Yes. So I think
Tell me, just out of interest, do you still have access to whatever those submissions would have been where Garth
yeah,
Bell was
yeah.
cited?
yeah, I've got them. I can send them all to you if you want to see them again.
Okay. I would like to correct something like that. I think I wouldn't like to be, I wouldn't like a judgment out that suggested I didn't put something before the court that I did. So that.
Well, much water has flown under the bridge since then. I'm not worrying about it, but I will certainly provide them to your ladyship if you wish to consider passing any comment about that.
Mhm.
Yes, so I think that the contention that this was a one-off offence would not be sustainable. Why? And so that's why I say that this can't realistically be compared to the circumstances that arose in the Wilson case. And in any event, your ladyship will see from the first page of the judgment in that matter that paragraph 4, respondent was convicted of having of having conspired to import 427.5 grams of cannabis with a high-end street value of 21,375, so significantly less, both in terms of weight and particularly value than the drugs in this case, in my respectful submission. But more importantly, I wanted to just take your ladyship to a portion of the learned senior magistrate's judgment. Yes, it's actually in the undisputed facts, so it's paragraph 12. But this was a particular feature of the evidence that the Crown did rely upon, that there was evidence in this case of the parties, and there was a third conspirator or co-conspirator who never on the evidence never came to the jurisdiction, was never before the court. But there were discussions along the lines of this being a good test run. You'll see that's a quote from one of the messages that was exchanged at the bottom of paragraph 12. And that, I think, actually comes from a discussion between former co-defendant and the third party who was believed to be overseas. But I recall there being a common theme in discussions between this respondent and the third party as well. That evidence was also before the learned senior magistrate. So I don't think anyone could contend that this case, the cases before your ladyship, was an example of a one-off. I mean, quite apart from anything else, Mr. Watkins, on the evidence, returned the empty hardback books to Miss Infante at the hotel, and she actually carried them out with her. Now, I mean, on one view, that was a rather amateur thing to do, because indeed it arose suspicion when the empty books were found on departure, but clearly they were carried for an intention, and albeit it's not one that Miss Infante accepted in the course of cross-examination, I believe the learned senior magistrate was right to find that that was evidence that they were intended to be reused. So it can't be right, in my respectful submission, to contend that this case is anywhere close to the sort of.
I'm sorry. I'm a little lost. Is my learned friend saying the magistrate made a finding that this was a one-off?
No, he didn't. No, I'm not.
I think he's distinguishing the one-off nature that I found in.
Oh, so this is a purely academic discussion.
Yes.
I was I know. Okay, fair enough.
Well,
fair enough.
I know that my learned friend thinks I'm a little too academic at times, and he may be right. I don't know that I'm being unnecessarily academic here. I'm just trying to say why I don't think that it's anywhere close to Tafari Wilson. So paragraph 16, looking at it now as I sit here, appears to say something that I have already said, at least once, if not twice. So I will not say it again. In my respectful submission, I think I can conclude here, subject obviously to answering any questions your ladyship may have for me. I submit that had the learned senior magistrate correctly identified the range that the learned former Chief Justice was identifying as appropriate in cases of this sort in the course of his general guidance in the judgment in Davis and reinforced in Holder, rather than focusing, as it appears he did respectfully, on the result in that case, he would have come to the conclusion that a higher starting point was merited than the one that he in fact selected. And for the reasons that I've sought to elucidate, he would not have discounted it as significantly as he did for the reasons that he gave, and nor would he have thought it appropriate to suspend any portion of that sentence. And for those reasons, in my respectful submission, the sentence in this case should, at least in principle, be increased to one between 18 and 24 months immediate imprisonment, and without any element of suspension. And I do have to accept, I don't exactly know what my learned friend is going to say about this. If I don't like what he says about it, maybe I will come back and reply. But I can see a compelling point to make, that even if your ladyship agrees with me and says that both sentences were too short or suspended to too great a degree, there is going to be some injustice, perhaps reflected from the fact that you're not practically going to be able to do anything to change what happened to Miss Infante, whereas Mr. Watkins is still here. So I can see an argument respectfully that there may be an arbitrary element to continuing to detain him in circumstances where she has already managed to leave through no fault of hers and no fault of his. So I'm really more concerned with setting straight.
I can settle the legal position without actually interfering with this sentence.
Yes, and
state what the
frankly,
position is, and I can.
That is actually a discussion my learned friend and I have been having for a while now.
Mm-hmm.
And if your ladyship
It won't
were
be the first time I've done something like that. It won't be the first time that the Court of Appeal has done something like that, where it may be for reasons peculiar to the case. In this case, one co-defendant has left and has come out of the jurisdiction of the court, so to speak. And the one that is in front of me, the respondent that is in front of me may feel a sense of real disparity and unfairness, and I might find that to be persuasive enough of a factor for me not to interfere with the sentence, but to still clarify what the position is on the law and how sentences should be approached when it comes to these kinds of quantities and circumstances.
That's a very helpful indication.
Well, yes, I respectfully, I agree. And I mean, if that's what your ladyship ultimately does, then I think I will have really achieved what I really came here to try to achieve. So I won't detain your ladyship any further unless there are any questions you have.
That would have been it. Actually, we've just addressed it. Thank you.
Thank you very much.
Thank you. Yes. Mr.
Afternoon, my lady. My lady, in light of the way in which my learned friend's submissions have developed and concluded, if I could say this as a preface. If you do the calculation, my client's due to be released and sent back home in about a month. Since he's been incarcerated, it's no dispute, my learned friend, he's had a child born to him, and he contracted COVID while he was in Westgate. It was a horrible experience. And I have been.
Did you say he had a child? Well,
his wife, who was with him, had to return to the United States, and she's had a child since he's been incarcerated.
I see.
He, of course, wasn't there for that. My other friend points out that's not a classic mitigating factor, but just by way of context. He also contracted COVID while he was at Westgate, which of course was not a very pleasant experience. And for those reasons, amongst others, I was, in fact, having discussions with my other friend along the lines of, listen, I can see why the Crown want this ventilated for precedent value. But I would also see an argument that my client, having appealed almost on the heels of the Crown, but now having abandoned that course of appeal, and the date having been set at a time when his co-defendant, who plays a fair role in this, has now left the jurisdiction, is beyond the jurisdiction of these courts. Perhaps we could try and settle this in the way in which his sentence wouldn't be disturbed, but the legal issues which are embraced could in fact be discussed, and if needed, be clarified for future reference. So to hear the court say that, in fact, is encouraging to me, but I will still go ahead and address the court, and I think I'll take it in very short bites on what I think the principles the court should consider if it does go on to consider the precedent value. And the first thing I'll say on behalf of my client is this, my lady. If this were an appeal against conviction, ineffective assistance of counsel would be the first ground, but it's not. You will notice from the record, some things speak for themselves, that my client's counsel asked almost no questions on the key issue of the Newton hearing with respect to weight, none whatsoever. And my client didn't give evidence. My instructions are, and again, if this was an appeal against conviction, it would be front and center with affidavit evidence, that he was never advised that he should give evidence on this. And no endorsement of the brief has been produced to me after being asked that he was so advised that he should perhaps give evidence on the Newton hearing if he wished it to be considered. So as a result of that, my learned friend's correct, doesn't have any evidence before the court or before the lower court as to what his side of the story was, and it's too late for him to give it now. We accept that, but I'd just like the court to take those things into account when assessing how much assistance he did and didn't give. I don't know how to say, it's lamentable that he received so little assistance in the courts below, and it has been the subject.
His assistance was forensically anorexic.
Anorexic, it almost didn't exist, and a complaint has been made, I can assure you, to relevant authorities with respect to the way that that was handled. And it's pretty obvious what happened. Two counsel came into the matter which were clearly out of their depth, and two other counsel have now or had to parachute into it to try and save it. I'll do what I can, but I just set that as the background. The other issue that we don't pursue at this time, but which we found to be very curious, was the fact that in a conspiracy case in which the court was unable to discern how much drugs were actually imported, the court conspicuously found that it would be approximately 2 pounds. I found that troubling. But in any case, what we do find is that, what we do submit to you is that the court's assessment of how much drugs may have been imported was a little speculative. And if the court's exact wording is approximately 2 pounds, then it could be less than 2 pounds. And I think that is something the court would have had in its mind as context when it would have set the sentences in this case, that it was dealing with a case, unlike the authorities before it, where there were specific amounts which could be weighed and valued. And in this case, the court was, in a sense, within certain ranges, shooting in the dark. I think the learned magistrate was very appropriate to have that in the back of his mind, and that may have, in fact, influenced why he didn't slavishly follow the authorities that my learned friend had placed before him. But if I could come, my lady, and I'll take it quickly through my script submissions, which I think will make things a bit faster.
I can tell you I've read them, but go on.
Yes, and then I'll just go right through them, my lady. You will see that I do. Here's the first point I need to make that I don't make in my submissions, and I notice this. There is a world of difference in modern sentencing trends, my lady, especially when it comes to cannabis, between those who import the drug for purely commercial reasons to make money and those who import it for reasons which are now recognized as legitimate, pain management and recreational use. So authorities which deal with people who are being sentenced for cannabis, in which it was assumed pretty much ipso facto that that cannabis was going to be sold in a criminal underworld for a profit, have to be automatically in a different category than those cases such as York, where there was an element of pain management. Well, in York, it was totally pain management. And in cases such as this, where there's a finding that there's an element of pain management and recreational use, but no commercial resale. That is so important. Because all of the authorities my learned friend have relied on, which say immediate custodial sentence, they do not take into account the practical realities of those cases in which people do import and possess cannabis for personal use and pain management. And the line that the court, in fact, this very same court has taken in cases such as Tafari Wilson, New York, reflects that dichotomy very sensibly. And I can't emphasize that enough. If you look in every jurisdiction in the Commonwealth, there is a world of difference between the way the courts treat those who produce, sell, import, possess any type of drug for commercial reasons, and those who have it for personal/medicinal, but non-commercial reasons. Those two sets of offenders cannot be treated the same. The other thing I'd like to point out before we move on, my lady, is an anomaly that I've noticed in Miller versus Davies for some time. However, this is the first opportunity I've had to address any higher court on it. And if I could ask the court to turn up Miller versus Davies, and in paragraph 2, in fact, from the head note, you'll note that it deals with importation and possession with intent to supply of cannabis resin, not cannabis. And my lady would be well aware from her experience in these courts that cannabis resin and cannabis have always been treated slightly differently, one considered to be a more powerful derivative. In fact, there's a statutory recognition of that. You recognize that 7 grams of cannabis is legal to possess, but 7 grams of cannabis resin was specifically excluded from that. So if we go down further to paragraph 1, you'll see on December 18, 2013, importing and possessing with intent to supply cannabis resin was the offense being considered in Davies, not cannabis. And if we go down to paragraph 2, we note that 608 grams of cannabis resin was valued at $60,000. 608 grams, my lady, is about £1.5 pounds. You've never seen £1.5 pounds of cannabis valued at $60,000. And these are the anomalies in Davies that I've noticed for so long, and I'm so glad I finally get a chance to address a court on them. Because the learned Chief Justice, I would say in Davies, was given very little real assistance on the distinction, and an assumption was made, which makes the authority a bit difficult to apply in these circumstances, and I'll demonstrate that. If we go over in Davies to paragraph.
All right, just can I ask you, did PC or PS, sorry, Saints deal with cannabis resin, or he probably would have had no cause to deal with that in his.
No, he didn't. He didn't. He dealt with cannabis and cannabis only.
But
He wasn't active.
he doesn't. Am I correct in my just very vague memory that used to see some explanation in the drug expert statement.
Yes, you did, in cases where there were cannabis resin to indicate the higher value, potency, and all of that. It wasn't in this case because they weren't dealing with cannabis resin. So Mr. Saints can't be faulted for it.
Yeah.
But I would pray and aid the court's extensive experience with these matters, that cannabis resin is often treated differently, has always been treated differently, and our legislature, and an example that stands before us now, has clearly treated it differently. It's more serious in their eyes. Always has been. So this authority for cannabis resin, and I'll demonstrate to you, is what it is, an authority for cannabis resin.
Sorry, we're in the MD. Are you pointing me so that I can?
My lady, I hope my camera stay okay. I managed to do
I
it.
do
I
accept
have the
if it
MD in
assists.
front of me, so you can just tell me where you're.
It would be in the
Mr.
possession
Sorry,
section.
one
It's
minute.
section 6. It is section
Yeah.
6. I accept if it helps, my lady, that
Thank you.
the exception that allows an individual to possess less than 7 grams of plant material does not authorize the possession of a similar amount of
Okay, thank you.
Cannabis resin. No, it doesn't.
I'm surprised to hear my own friend make that concession, because he and I have actually argued that point in another place where he took a different position, but I have noted and agree with what he has said about it today.
Okay.
Oh, Mr. Richards, you know that I argue on behalf of clients, and different clients require different arguments.
Okay, there you have it. Yes, thank you, Mr. Richardson.
In any event, my lady, if I go on now and take you over to paragraph 11 of the judgment,
Mhm.
and his lordship uses this very troubling term. He says, assuming that the 3-year term included in the standard 1/3 discount for a guilty plea, the basic sentence in Davis versus Cox may be calculated as 4.5 years. And then he gives the algorithm. And then he says, assuming there is no dramatic difference in the commercial value of comparable weights of cannabis and cannabis resin, this authority strongly suggests the submission made by Crown Counsel that the basic sentence for the offense involved in the present appeal, as regards sentence imposed in the magistrate's court level, is in the 4 to 5 year range. And if we go down to paragraph 15 now, we will see. In summary, Davis versus Cox fixes a tariff for cannabis importation sentencing, which is inconsistent with modern sentencing trends. That almost puts Davis versus Cox in the grave. In any event, the Crown conceded just over a year ago that 5 years imprisonment is the basic sentence for a cruise ship employee importing an amount of cocaine comparable in street value to the cannabis resin involved in the present case. He's not even discussing cannabis anymore. We're talking about cocaine and cannabis resin of comparable values. The basic magistrate's court sentence for importing a comparable amount of cannabis resin without aggravating factors today must be in the 1 to 3 year range. This is an authority for cannabis resin, unwittingly, and not cannabis. The subject matter of it is cannabis resin. The eventual pronouncement of the range is in relation to cannabis resin after considering comparable amounts of cocaine. And it's found to be 1 to 3 years. So I'm a little hard pressed to see how Miller versus Davies can provide any definitive guidance to this court when it's sentencing someone for cannabis.
And then he later cites the learned Chief Justice, Mr. Kawley, cites Miller and Davis in the.
Henry Huggins, and I'll move on to that next, lady. He cites it in Henry Huggins and relies on it to set the tariff in Huggins without again realizing.
But one second, let's get it.
And just from looking at Huggins, my lady, we can see the error that is crept in. If you look at paragraph 1, the introductory section of Huggins and Hilda, you'll see in the first paragraph, the appellant Hilda, a person of previous good character, having been convicted following a trial of importing and possessing with intent to supply 1,100 grams of cannabis. And look at the worth, between 19,000 and 5,500, depending on who you ask, I guess. Certainly not the comparable
Depending on
range.
how it's sold.
Depending how so. It's not certainly not the comparable range of cannabis resin we were looking at just recently in Davies. Where is it? And 2.5 years, that was eventually reduced. The second paragraph, Mr. Henry Huggins was a person of previous good character. He too was convicted following a trial of importing and possessing with intent to supply. Now let's remember, in both of these cases, there was no element of personal use. There was no element of pain management. And there certainly was to be presumed, and they were sentenced on that basis, that this was for commercial supply. So that distinguishes Huggins in and of itself. But the previous submission I've made to you about the error in the Davies decision that we've all been following, I think that's fatal. Is it for cannabis resin or is it for cannabis? And we've always treated cannabis resin differently. Always. No one would argue that. So if Davies is an authority for cannabis resin, then clearly the range that the learned senior magistrate applied in this case with respect to cannabis would be well within what he was entitled to do. And let's look at what he done. In the round, this is what he done. He basically made a finding that approximately 2 pounds of cannabis had been imported. He made a further finding that that cannabis was imported for personal use in terms to treat pain and the like, and that Mr. Watkins would have shared some of it with friends. But he specifically made a finding, I don't believe he was going to sell it. That's the real gravamen of the sentences that are handed out. And that's why when the courts say we should sentence on the basis of street value, that's why there should be a distinction in the way these cases, because street value becomes irrelevant in the face of a positive finding that there was no commercial resale intended. This is not the classic case. And yes, in quite shortly, the learned magistrate, I think he was a magician in the way he trod a very careful line between commercial cases, the usual run-of-the-mill case, and this case, which wasn't quite that, but it's somewhere in between. So here's what I'll do. I'll give them this sentence. I'm going to reduce the custodial portion to 9 months. And no, I'm not going to suspend all of it because it's not quite yours. I'm just going to suspend a part of it. My lady, I can't really say much more to say that. I think he got it absolutely right when you look at this in the wrong. He really did a very careful analysis of these cases, and he came down with the right result when you really analyze it. And I won't detain you any further in a lot of the discussions prepared, but that's the firm belief that I have, that this magistrate did an excellent, stellar job in a case in which the facts he was faced with were somewhere between the skyline and the Charybdis. It wasn't commercial supplies, it wasn't normal authorities, and it wasn't York and the rest that he had to find a new aid. And I think he did an excellent job. And if this sentence is something that perhaps my lady would have maybe erred a little higher, maybe erred, I don't know, maybe not, it is not manifestly inadequate. Mm-hmm. It might be in some people's eyes inadequate. As the test sets out, some people might say, well, but no one would say something is going wrong here. It's certainly wrong in principle. Or wrong in principle. It's certainly within the right range. Our lady could have fine. Listen, I personally might have given more, but on all the facts of this case, this is certainly within the acceptable range. And that's the finding I'd ask the court to make. And if the court's not with me and finds that there should have been a higher range, I'd ask you to not increase, just as a matter of principle. Mr. Watkins' sentence, make the pronouncement so the Crown can use it as a future president, if that's the way it should be, and allow him to keep his release date, which I think is December 2nd. Those would be my submissions. Thank you.
Thank you. Mr. Richardson. Mr. Richards, did you want to make any reply on the law?
My lady, I suppose, I think that my learned friend conceded that this wasn't in his submission, so the only slight concern I have, and I don't want to repeat the submissions I have already made, but he has now addressed you specifically on Davis being really a cannabis resin case, and I think he's saying it's different. I suppose what I would say is that it would appear, if you set Davis in the context of what the learned Chief Justice said in Holder, that he did not regard the range that he had identified in Davis as being confined to cannabis resin cases, and applied it willingly to cannabis cases. So it appears that counts against Mr. Richardson's argument to some extent, and to the extent that he appears to be submitting that that was a mistake, I respectfully submit that is it's hard to see how the former Chief Justice could have made that error. But I suppose the difficulty we have, ladies, is that we don't have a range of cases before you now where we could test the proposition that my learned friend has advanced to the effect that cannabis and cannabis resin are always, as he emphasized, treated differently. I mean, historically, I think it may well be true that cannabis resin was viewed a little bit more seriously because it tended to have a higher concentration of the active ingredients than herbal cannabis. But you don't see it so much anymore because we get more of the hydroponically grown strains of plant material that do have a higher THC content than plant material used to. And that is the type of plant material that we're dealing with here. Now, I can't say that it's always going to be as high as the average concentration of THC in resin, because we all know that the content of the active ingredients in resin isn't necessarily static anyway. It fluctuates as it does with herbal cannabis. But I don't see my learned friend putting before you, and I didn't anticipate that this was a distinction he was going to make, so I haven't sought to do it, a range of disposals from which one can really draw the conclusion that they are always treated differently. That's not my immediate experience. And I can't put the cases before you to substantiate or contradict that at this time. Certainly, as far as the Chief Justice seems to have been concerned in the two judgments that we've been through, there was no reason to draw a significant distinction, in my respectful submission.
May I simply ask the question, Melanie?
Yes.
My learned friend,
question of, or is it just
on what Mr. Richards has just said, this discussion, I think, is quite illuminating. My learned friend, I think he does hit on, we don't see cannabis resin as much anymore, but we do see shatter, which my learned
We
friend,
have seen shatter, yeah.
my learned friend will concede is definitely treated more seriously than cannabis. That's the new resin.
Oh, shatter is treated as more serious than plant material.
Yes.
Yeah, I don't think I have a huge quibble with that, but we don't have a we don't
Always,
really have
always has been.
we don't have a
I think the
guideline case
question
on
is
shatter.
degree, to what extent, how much more serious is it to be treated by the courts or has been treated by the courts? And I understand Mr. Richards to be saying that we don't have any real body of case law from which we can, take a view on that. I would like, if you would also maybe just briefly address me, Mr. Richards, on Mr. Richardson's submission that when you look back at this, at the case law, the reality arising out of the distinction between commercial supply and recreational and medicinal use has not been recognized in the older case law. And that is something which the courts should be taking into account in this age. What do you say to that?
Well, I suppose the reality is that in the vast majority of cases involving $100,000 worth of cannabis, there is no argument about whether it is commercial or not commercial, because it's just taken as read that it's commercial. It's an unusual scenario, perhaps, that you find a case where, notwithstanding the significant quantity involved on the findings, there is also a finding that such supply as was intended by the custodian was not commercially motivated. But what my learned friend did say in the course of his submissions, if I recall correctly, was that there had been increasingly recognized legitimate uses of cannabis. And he spoke then about both medical and recreational use. And I don't accept that submission as correct. I do recognize that the law does now allow individuals to apply to the minister for a license to import or possess cannabis which they can seek to justify on medical grounds. And your ladyship will recall that that's something that Ms. York was seeking to do. And I think, in fact, if I remember correctly, she did ultimately succeed in such an application, I believe. If I'm wrong about that, then it'll be reflected in the judgment. But that doesn't equate to anybody having said that recreational use is legitimate.
Don't open a can of worms.
No, sorry. I did not understand Mr. Richardson to be making that point. I think.
I mean, if he wants to, don't do that.
I don't know what my learned friend's telling me not to do.
Here's my question. Question, and this is what I took from Mr. Richardson's submissions. Is the court to make a distinction in terms of the gravity of the offense between I'm going to say possession, just to be broad about it, possession for the purpose of recreational or medicinal use on the one hand, and commercial profit on the other. It's not, I did not understand Mr. Richardson to be suggesting that recreational use is lawful or anything of the sort. I understood him to be inviting this court to recognize, when you look at the mitigating and aggravating effects of any particular case, that we should be recognizing that there is a difference.
That's all I was saying.
Commercial gain, something that's being done for commercial gain, and something that's being done for medicinal and or recreational use, be it as it may, that it may be unlawful in any event.
That's correct.
So I don't dispute that it's a relevant fact.
Okay.
I think it's a question of how much weight has to be attached to it. I do respectfully suggest that it's a false dichotomy to say that there is on one hand medicinal and recreational use, and thus therefore to equate those two to some extent, and on the other hand commercial use. I don't think that we can say that.
In three different classes.
I think that's more accurate, respectfully, in my submission. Because I mean, I don't know whether he's suggesting that the amendment to Section 6 is heading in this direction, but I don't see that the legislature has ever expressed the view that recreational use of cannabis is legitimate. They have authorized.
The legislator has not. We're not dealing with the lawfulness or unlawfulness of it. We're talking about the gravity for the purpose of sentencing.
Yes.
Let's say that all three uses in this particular case would be unlawful, whether it was for medicinal purposes, recreational, or for commercial gain. Let's say that all three classes of activity would have been unlawful.
Yes.
But should I not recognize that there is a more serious element to the cases of which are motivated by commercial gain, as opposed to those which are motivated by, let me say, unlawful medicinal use or unlawful recreational use?
Yeah, I don't think that I can sensibly contend, my lady, that a clear case of commercial, where the supply that is intended is clearly commercial, is not more serious. Clearly, if there were evidence that the individual had made or was intending to make significant profit from the enterprise, then I would be pointing to that as an aggravated feature. So I can't sit here and say it's the same. It's not the same. But in my respectful submission, those who sell cannabis sell it to those who use it recreationally. In the main, some of them may use it medicinally, but most of them use it recreationally. And there is no extent to which, in my respectful submission, recreational use of cannabis has been legitimized to any extent legally. So I don't think that it is a factor that much weight should be attached to, but I don't contend that you should disregard it and treat recreational use for these purposes as precisely the same as commercial motivation. Obviously, if it was clearly commercially motivated and the magistrate had found it to be so, then I would be pointing to that fact as an aggravating feature. And I can't, because I have accepted that factual finding as correct. So I do accept that is a factor to bear in mind. I mean, the reality is, of course, that as I have said, the court doesn't actively confront that question in the vast majority of cases. It's unusual, if not unprecedented, to find a situation where the court has said that a quantity of this size was not imported for at least a partly commercial purpose, or in fact, I'm not expressing myself precisely enough, where it has positively found that it was not commercially motivated, because the court doesn't usually enter into a consideration of that question. Any case involving the importation of this sort of value of cannabis would be treated, I imagine, as part of the standard line of cases, and the judgments that have been handed down haven't said you should take a significantly different approach. You should reduce the starting point by a particular amount in order to reflect any determination that the intentions here were not commercial. But still, I return to the fact that whatever the intentions were at the point of importation, there is, on any view, a significant amount of cannabis that is now beyond the reach of the authorities, because this importation was, to that extent, successful. And I can't but think that Mr. Watkins would have been in a far better place to contend for the sort of sentence that he got, and perhaps even a more liberal one, if he had come to the court with
Is my learned friend taking a second bite at the cherry, or is he addressing the question to the court? Because you're repeating everything you said before. You've answered the court's question.
Fair criticism.
Sorry. And to answer your question,
I won't trespass upon Mr. Richardson's patience any longer, but does your ladyship
it's Friday.
Does your ladyship wish to hear anything more from me?
No, I think that you have certainly assisted me in answering the question that I put to you. And I've found the submissions from both of you to be very helpful. You know that I'm going to reserve, and I'll come back with a written ruling. And I will aim to do that within a 6-week period. I do have one last question, notwithstanding that it is Friday at 4:26 p.m. Why did this appeal, what was the delay in the bringing forth of this appeal? I can see that there was some observation made that the appeal was not listed expeditiously. Can you
in actual fact, that comment that it wasn't listed expeditiously might be a little unfair, in that it wasn't listed expeditiously in light of the fact that Miss Infante was due to be, leave the jurisdiction.
But in terms of all September 2021 ruling, am I correct?
Yeah, absolutely. By comparison with any other appeal, it's been listed very expeditiously. It's just that unfortunately not expeditiously enough.
Yes.
Right. No, my lady, if you're asking whether they dragged the feet, no, they moved pretty quickly, actually.
Okay. All right.
I mean, it doesn't necessarily need to find its way into the written judgment, but this is a situation that has arisen before. It actually arose in the Batchev Todorov case, which was an appeal from the Supreme Court of the Court of Appeal, where we're appealing the sentence, and the individual is released from such sentence as they received at first instance before the appeal is heard, and there is nothing that we.
Let me make a suggestion to you. If you correspond with the court, specifically requesting for something like that to be brought to my attention, in all likelihood, you will get a very quick listing.
Yes.
That's true.
You really have to bring it to the attention of the judge.
Yes.
You ask for the correspondence to be placed before the judge and an early listing. Just make a short and succinct request, and I imagine that you would get a quick listing.
Yes. I mean, it's unfortunate that the statute doesn't really help. Neither the Criminal Appeal Act nor the Court of Appeal Act really provide for any mechanism to deal with that particular situation. Because even supposing that we had managed to mention the case before your ladyship, even if we hadn't had the actual appeal, I am not myself clear as to what powers you would really have had at that point. It's the only obvious solution to the problem is to expedite the appeal itself, which is obviously difficult.
Well, practically speaking, it's not. You just corresponded with the Supreme Court, and I deal with the criminal appeals, all of them. Yeah. So you can be pretty confident as to who the judge is that you're concerned to address. And if it's not me, then I'm quite sure that the judge who is assigned would be identifiable, and that
Yes.
correspondence would be placed before that judge. But that's a practical approach until there is something more formal in place. I imagine that that would still be very effective.
Well, I'm grateful for that, and we will bear that in mind. I mean, happily, it's only arisen twice in the time that I've been in Bermuda, and so it hopefully won't arise again too soon. But as and when it does, I shall take your ladyship's advice.
All right, well, I wish everyone a good weekend. You are correct.
You
It
too.
is now Friday, 4:30. That is officially the end of the court session. So have a
Thank you,
good
my
one.
lady.
Thank you. Judgment reserved.
Thank you.